Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have some breaking news out of the Indiana Appellate Court, where the high-profile Delphi case, as it has been called, has been proceeding based on Richard Allen's March of 2025 notice of appeal, where Mr. Allen is appealing his conviction in an Indiana state court before Judge Gull, where a jury came back following trial, rendered a verdict that Mr. Allen was guilty of the tragic unalivings of two young friends, Abby and Libby, in February of 2017 in a small town in Indiana. After Mr. Allen filed his initial brief on the merits, as he did, it appears on the docket December 18th, 2025. The next step in the briefings was the response from the state of Indiana, and they did respond. It's available on the docket March 25th, 2026. And then finally, the third step in the briefings, Mr. Allen's reply, which was docketed on the 28th of April, 2026. There is a new item on the docket dated April 29th, 2026. This is a notification from the clerk of the appellate court to the appellate panel that will be reviewing the briefings, the petition, the response, and the reply to determine if Mr. Allen's conviction should be tossed out of court, and in the alternative, if a denied motion for a Franks hearing should be granted and the matter remanded to the state court. That will be up to the appellate panel to decide. The notation of the 29th of April also indicates that Mr. Allen requested oral argument. There is a motion for oral argument. That's a hearing that would occur before any decision is made by the appellate court. He wants the opportunity, because of the complexities involved in the case, amongst other grounds, to come before the court one final time and pitch his grounds for why reversal is proper. At any oral argument, the state, who has vigorously denied that there is any grounds to do anything but affirm what happened in the district court, would also come before the appellate panel and explain one final time before ruling why their position is proper. The reply brief that was just filed replied to the response. And here, Mr. Allen raised such arguments in replying to the state's response that the trial court indeed committed reversible error by admitting evidence seized from an unconstitutional search, and thereafter denying a Franks hearing. A Franks hearing is a hearing named after a famous Supreme Court of the United States case, Jerome Franks versus State of Delaware, and stands for the proposition that if a defendant proffers sufficient evidence demonstrating the impropriety of the warrant affidavit, that defendant should be entitled to come before the court in an evidentiary hearing and demonstrate why the warrant should be thrown out. He has also raised the issue that the trial court erred by admitting Allen's confessions, that the appellate issue is preserved because the trial court made that clear during the trial, and that the trial court erred by refusing to consider certain evidence that undermined every argument that the state makes in its response. Now, why it's important for Mr. Allen as the appellant to show that the matter was preserved, it was raised in the lower tribunal and denied, is that an appellate court must look at a matter like this to see if it was raised, this matter of Mr. Allen's confession in the lower tribunal, and if any errors were committed in allowing the confession into the case. He is also asserting in the reply that the state's prolonged confinement of Mr. Allen constituted coercion, even under the law that the state cites within its reply. He's stating he received an unfair trial, that he has a federal and state constitutional right to present a complete defense, and evidentiary rules that exclude critical defense evidence on grounds disconnected from the rule's purpose violated that right, and citing to a United States Supreme Court case. This reply brief, as well as all of the filings in the case, are free for the public to review. I have included a link to the appellate court's docket. You can look up the case, read the briefings, and all of the other filings that have been submitted thus far. At this point, we are awaiting a potential response from the other side regarding oral argument. If oral argument is granted, we will, of course, advise you. If it's denied, we will advise you. And then the next step would be for the appellate court to rule. We are expecting a ruling, barring any unforeseen circumstances, later this year. Will Mr. Allen succeed on appeal or not? That is the matter that is at issue in Allen versus State of Indiana. This will now conclude this episode of the Indie Zone. Thank you for joining us here today.